Hi, this is the Business Guy. Let's talk about the homestead exemption and how it protects your home from lawsuits. A homestead generally refers to the primary residence owned and occupied by a person or family. So a homestead exemption is a legal provision designed to protect the value in a principal dwelling place. Homestead exemptions can provide asset protection from creditors for at least some of the value in a homestead. Typically, no creditor, with the exception of a mortgage holder, taxing agency, or mechanics lien, that is, liens placed by those who have provided some home improvement services, for example, may seize more of the equity than the homestead laws allow. Now, as a background, I've been the CEO of Asset Protection Planners for over 30 years, the nation's largest firm that protects assets from lawsuits. We have attorneys and experienced consultants on staff who set up asset protection trusts and other tools. Now, a homestead exemption may also refer to statutes in some jurisdictions that offer property tax deductions for a primary residence. For example, as of this video, Article 7, Section 6 of the Florida Constitution reduces the value of a home for assessment of property taxes by $50,000. It may also refer to the extra provisions for spouses and children. By the way, if you like this free info, subscribe so we can see each other again, and text this video to people who need it. Now, in Florida, a married person must have the consent of both spouses in order to sell a primary residence, even if the property was paid for and is in the name of only one spouse. Upon death, the surviving spouse can enjoy a life estate and use the home until passing. Alternatively, a widow may elect to timely file and take a 50% interest in the home, and the remaining 50% is held in a life estate for the benefit of the decedent's children. So that's a little background on what people mean when they say homestead, but in particular, this program focuses on the amount of equity that one can protect from judgment creditors in each jurisdiction. So let's talk about that now. We have some people ask us all the time, if somebody sues, can they take your house? And the answer is yes, if you live in a state without sufficient homestead protection, unless we set up an equity stripping arrangement, which we'll touch at the end. Homestead exemption statutes vary by state. State, federal, and territorial homestead exemption statutes vary. Some states have provisions, if followed properly, allowing 100% of the equity to be protected. These states and territories and districts include the following. The best known are Florida and Texas, and there's also Arkansas, D.C., Iowa, Kansas, Oklahoma, South Dakota, Puerto Rico, and American Samoa. On the other hand, there are states such as New Jersey and Pennsylvania where you don't get any homestead protection at all. Even if you have $1 in equity, somebody can sue you and snatch your home. But hold on, if you do live in a state that only protects a little bit of the equity, hold on for ways to protect yourself. Whereas the degree of protection in New York varies by county. What is more, with the 2005 federal bankruptcy code revisions, residences purchased within 40 months, that's 3 years and 4 months of a bankruptcy filing, receive a maximum exemption of $125,000. So even if you move to Florida or Texas, if you either file for bankruptcy or your creditors petition the court to force you into bankruptcy, your creditors can take your house away from you unless you live there for 40 months. So what we're saying is there is great diversity in homestead protection state by state. Some states allow you to protect 100% of your home, others protect little to none. Some states allow married couples to double their exemption, others do not have this provision. Some of the states make you file a declaration of homestead before filing for bankruptcy. In others, it's automatic. The majority of states require you to follow the state homestead rules, and some allow you to choose between the state and federal homestead exemption statutes. We published the first and only list that we could find that includes not only all U.S. states, but also U.S. territories. There are some notable variations among some of the U.S. territories. In American Samoa, your ethnicity determines whether or not you get protection. For example, it allows for protection only for those of Samoan or Pacific Islander descent. Northern Mariana Islands, another U.S. territory, allows one to keep the amount of land needed to support oneself. In Puerto Rico, they require a note to be certified by a notary public and filed with a land registrar. Can I keep my house if I file for bankruptcy? Whether or not you can protect your home can be a major consideration when contemplating a bankruptcy filing. The majority of states and territories do allow some protection under their homestead exemption statutes. This exemption is a factor in both Chapter 7 liquidation bankruptcy as well as 13 where a payment plan can be arranged. So by knowing the rules, you may be able to protect some, most, or all of your personal residence and decrease the repayment amount in a Chapter 13 filing. Homestead exemption laws change. If you do a Google search for homestead exemptions by state and territory, you'll see a list for the amount of homestead protection that each state and territory grants. Now, please keep in mind there are well over 50 states and districts and territories listed on our website, and changes in regional and federal laws and rulings may occur before we have a chance to update the list online. Additionally, some of the data on which we relied may be inaccurate or may have been misinterpreted in our findings. So we think our online homestead exemption table is accurate, but use it as a helpful reference, and you're responsible for confirming the accuracy of this information before relying on it. In addition, there may be exceptions for child support, taxes, and/or acquiring real property with criminal proceeds. Okay, what about married couples? Can a married couple get homestead protection on two separate properties? The answer is no, generally not. A married couple only gets one. Now, what about a second home? Well, you only get one homestead property, and you have to declare which one is your primary residence, generally by living in it for more than half the year. You have a driver's license in that state, your cell phone records, if your opponent requests a subpoena, shows you were in the home most of the time or at least came back there in the evenings. There are exemptions for members of the military who are stationed overseas, and in Florida, there are even exemptions for those who are incarcerated for extended periods of time. The house is not protected, however, if somebody used stolen money to buy the property. So you can't rob a bank and buy a house with stolen money and go out and buy a mansion in Florida. That's not going to work. There are also property size exemptions. For example, if the property is in a municipality like a city, you only get half an acre and 160 acres if it's outside the city limits. Now keep in mind the homestead exemption is only one small part of an overall plan to protect assets from lawsuits. So if you have lots of equity the homestead laws don't protect, what do? What we do is what is called equity stripping. That is stripping the equity out of the property so that when somebody sues you, there won't be anything of value left. Now here's how it works. Say somebody wants to sue you, they call an attorney, and what's the first thing the attorney is going to do? That's right, they're going to do an asset search to find out how deep your pockets are, what assets you have, and if you have a bunch of real estate out there with a bunch of equity in it, the attorney's going to say, hot dog, heck, you don't even have to pay me. I'll just get paid out of what we get out of them when we sue them. So they'll take the case on a contingent fee basis. But if they don't see any property because of the privacy strategies we employ, or if the person suing already knows where the assets are, and we've employed strategies to make them show their mortgage to the hilt, the attorney will either not take the case or will simply settle for the insurance policy limits. So what we do is we set up an LLC and we record an equity line of credit, mortgage, or deed of trust against the property. That is an equity line of credit, so no money changes hands. But to the outside world, it looks mortgaged to the hilt. If the creditor tries to get past this defense, we have a third-party lender who can buy the mortgage and put the proceeds in a you can't touch it account in an offshore asset protection trust that we set up for you. You can see more details on the Business Guy video channel or on our podcast on equity stripping. So that sums up homestead protection for your personal residence. Subscribe so I can see you again. This is the Business Guy.